Our next speaker is Locke Bowman. He's a partner at the law firm of Loevy and Loevy. He was one of the counsel representing plaintiffs in a class action lawsuit brought by journalists, protesters, and members of the clergy, alleging that the federal agents took unlawful actions to disrupt their protests and use unnecessary force, such as tear gas and pepper balls, against peaceful protesters outside the Broadview detention facility. Mr. Locke's remarks will describe those actions and what the status of the lawsuit is.
The case that we've been working on has been a labor of love on the part of a lot of folks here at Loevy. We were commenting yesterday that the entirety of our paralegal staff has touched this case in one way or another since it was filed about a month ago. And more than a dozen of us in the firm have had a role. We're collaborating with Civil Rights Clinic at Northwestern, with the Police Accountability Clinic that Craig Futterman is leading down at the University of Chicago. The ACLU is involved in the case. Protect Democracy has stepped up and come in and provided insight and help. And I suspect I'm missing some of the roster of the lawyers who have sacrificed their practices and stepped up in order to address the situation on the streets. Jonathan is talking about the situation in Broadview. Our case centers on the situation in the streets. As Carl said, not just around the facility, where protests initially focused and initially attracted local and national attention, but expanding all around the city as ICE and the Border Patrol folks have accelerated the tempo of Operation Midway Blitz, and spontaneous protests have emerged all around the Chicagoland area, notably in East End, in Logan Square, in Old Irving Park, in Edgewater. The list goes on. And it's been kind of get emotional about it. It's been kind of a remarkable emergence of our city and the surrounding area standing up for ourselves and saying no to what's to the brutality that we're forced to observe every day. The case is called Chicago Headline Club, which is an organization of journalists, advocacy organization for people who practice in that profession. The case includes plaintiffs, additional journalism plaintiffs, plaintiffs who are religious folks, who wish to exercise their religion in the presence of people who are protesting, in the presence as close as possible to those who are being detained, and as well in the presence of these guys who have been, and women who've been recruited into the service of the Department of Homeland Security. And last, far from least, the case includes individuals who've shown up not just to express opposition by chanting, by shouting, by cursing, but also people who simply wish to bear witness and record the events. The case makes a claim on behalf of everyone under the First Amendment of the United States Constitution, as well as a claim under the Fourth Amendment of the United States Constitution, which arises because of the really extraordinary brutality that is being practiced against folks in response to their exercise of their First Amendment rights. As to the religious folks, it also includes a claim under the Religious Freedom Restoration Act. The case was assigned to Sarah Ellis. She issued a temporary restraining order fairly shortly after the litigation was filed, which cabined what the federal agents in Chicago could do in response to protests. The restrictions included basically allowing people their right to be in public places without being shoved or attacked. Specific restrictions were placed on the use of munitions, initially at Broadview and then later all around the city and all around Chicagoland. Federal agents were using tear gas and pepper balls and inflicting pretty serious injury as a result. And we've all seen it on the nightly news day in and day out. The TRO required the federal agents to give journalists the freedom and the space to practice their profession separate from those who are actively engaged in protests. And it required the use, eventually it was modified to require the use of body-worn cameras and to require the agents to wear some form of identification. It's interesting, to see Judge Ellis, who is a long time, prior to going on the bench, was a longtime City of Chicago police lawyer, looking at these activities and seeing a real horrific failure of proper police practice. And she was particularly incensed that people working for the federal government couldn't be identified. And that was a particular part of the TRO. As the litigation progressed over the next couple of or next 4 weeks or so, one of the things that a lot of people spent a lot of time was accumulating evidence of violations of the TRO. It's pretty apparent that the federal government had no interest in complying with the TRO, despite the lip service of its lawyers. And over again, we submitted notices of violation of the TRO. One of the interesting facts about the case, speaking of the First Amendment, was that the Secretary of the Department of Homeland Security, Kristi Noem, who was the lead defendant in the case, early on came and gave a speech to the federal agents who were working at Broadview. And among a few other things, she said, I want you guys to hammer hard on these folks. I'm paraphrasing, I'm not quoting, but it's a pretty close paraphrase. I'm not getting it wrong. She said, go hard after these people for the way they are talking, for what they are saying, for who they are associated with, for who is funding them, and for what they are advocating. So we had unusually strong evidence of viewpoint discrimination in a First Amendment case that proceeded in part on the theory that the plaintiffs were being retaliated against through violence in response to their particular viewpoints. We went to a preliminary injunction hearing last week, as Carl said, and I was quite moved by the evidence from a purely there was thought put into it, but it was a group of people selected to be witnesses. Could have been multiplied tenfold, 20-fold. It included a woman from Edgewater who was not well. She had a cane and was suffering from a back injury. As she was driving to her home in Edgewater, she saw a landscaper being detained by some federal officers. She got out of her car and used her phone to videotape what she was seeing. Stayed out of their way. At one point, she said to them in their hearing that they looked like stormtroopers, which she explained on the witness stand was a reference to Star Wars, not to Nazism. After this happened, she took her phone, got back into her car, pulled out of her parking spot, and drove onto her block. She was blocked by a federal agent. Another guy came up behind her, blocked her in, got out of the car, pointed a gun at her. They started pounding on her car. And eventually they stopped and went away. As she testified, her voice broke as mine has done. And she said, I'm not well from this. And I think that was emblematic of how what is going on has affected our community. I do not believe, though I'm a lawyer, that there's a constitutional amendment that quite covers the injury that we're talking about. I don't believe that the founders covered the possibility that the federal government might declare war on a community within the United States of America for no particular reason. Judge Ellis, in issuing her oral ruling granting a preliminary injunction, started with a recitation of Carl Sandburg's poem, Chicago. And it was really quite moving. In a very real way, the case was about competing narratives as to who we are as a community. The federal government casts us as a hellhole of violence and mayhem. And as the Sandburg poem reflects, and as we all know, we are something very different. Part of the evidence at the preliminary injunction hearing was a demonstration that over and over again, in justifying their actions, the federal agents have lied, full on lied about what provoked them to violence. The government immediately appealed after the preliminary injunction was issued. There is a motion for stay of Judge Ellis's injunctive relief that is fully briefed now in the Seventh Circuit. Expect a pretty prompt ruling on that, which will determine, which will set a tone for the future of this case. And that's my summary.
Well, that was a very powerful statement that you made, Locke, and I hope we'll find a way to use that in our ongoing public awareness campaign, because I think that's the sort of thing we want more people to know about.
Yeah, I have a question. What else? So are you in the process of discovery now, Locke?
Yeah, it's interesting. I'm glad you brought that up, David. One of the things that we've heard on the news is conflicting signals from the federal government about the future of Operation Midway Blitz. On the one hand, we learned that Gregory Bovino is no longer on the case in Chicago. He's elsewhere, and a lot of the Customs and Border Patrol agents under his command have also left. By the same token, the DHS folks insist that there's no change of tempo or wind down of Midway Blitz, and that things will continue. Our stream of information about violations of the judge's directions continues, and then the government has also said that come March, Mr. Bovino and his crowd will be back in full force after wintering elsewhere. We were in court yesterday for a status hearing. Judge Ellis, without setting a trial date, indicated that she thought it would be sensible to have a full trial on the merits in March, as she put it, so that everybody would understand the ground rules for immigration enforcement in the Northern District of Illinois, starting in March when this anticipated ramp up occurs. We are going to report back to her after conferring with the government next week about a proposed discovery schedule and all of the other accoutrements of civil litigation in federal court.
Yeah. A couple other questions. Does your lawsuit cover the raid on the South Shore apartment building that they conducted and made a video of?
No, I don't think that it does not occur, it does not include the injuries suffered by the residents of the building. I mean, they were not engaged in First Amendment activity at the time of the raid, so that they would not be part of the class. If there were people from the neighborhood who came and observed or responded in some way to what was going on, they would be members of the class.
Anything more for Locke? Well, again, thank you very much for your presentation. It was very informative. Locke, again, thank you, and you're welcome to stay for the rest of the meeting if you wish. That brings us to next item.